Thank you, everybody, for coming. You saw and heard a little of me in that documentary. I can explain a little more of the legal context, obviously, because that's what I do, but there's a book on the silent auction table, and the Diab case is really a story of a wrongful conviction in the making. Wrongful convictions are the ultimate failure of a justice system. And it's rare that you watch one unfolding in front of your eyes. It's rare that, we've caught wrongful convictions after the fact with improved scientific methods and DNA and so on. And you've heard about cases from Truscott to a number of them. This case, though, has been crying out from the start about innocence. And yet, the case represents the train wreck for the justice system of a wrongful conviction in the making. And the book that's on the table, called An Officer and a Spy, is actually, it's fictional, but it's based on the true story of the multiple trials of Captain Dreyfus in 1895 and thereafter in France. The parallels are shocking, really, because Dreyfus was accused conveniently because he was an unpopular Jew in anti-Semitic France. The evidence against him was spurious handwriting evidence and secret intelligence. He was convicted not once, but twice. He spent many years on Devil's Island. And but for the ongoing efforts of his brother, and then ultimately the engagement of luminaries in France who took up the case, and J'accuse was written in the principal Paris newspaper and was an indictment of the evidence and the case against Dreyfus, and led ultimately to France freeing him. He was never acquitted, despite the horrible evidence. And here we are in now the 21st century, and it's a replay, and it's shocking that it's a replay based on secret intelligence and handwriting. Only this time the target is an unpopular group, a Muslim, originally from the Middle East, a Canadian citizen now, a convenient target, and of course complicated by the unfortunate events in France, and therefore the paranoid climate that really compromises the ability to get a fair trial. So the book is well written. Anybody who reads it will recognize the elements of Hassan's case in it, and the heroism it takes for a person like Rania, who has led the battle with the help of all of you, to keep fighting for this man's freedom. It won't happen without you. It didn't happen without Dreyfus's help from civilians in France. It would not have happened but for that. So the failures that I see that have happened, I mentioned the state of extradition law in Canada. The history of the extradition law here is somewhat interesting in that it really became the child of the Department of Justice. Most lawyers in Canada have never done and know nothing about extradition or the law of extradition. It's a real backwater, not only of the law, but even of the criminal law. It's a part of the criminal law. 99% of criminal lawyers will never have done or encountered an extradition case. So the reigning experts who have made all the law have come out of the Department of Justice because, with the help, a very fine jurist, Mr. Justice Laforêt, who ended up on the Supreme Court of Canada, and who came out of that Justice Department and who did extradition work for the federal government, really shaped the law of extradition in Canada. Extraditions used to require sworn evidence. It may surprise you to learn, every one of you as a Canadian, that your freedom, your liberty can be taken away from you, not with sworn evidence, as you expect in any Canadian courtroom or probably any legal proceeding you've contemplated. In extradition, the evidence does not have to be sworn. It took too much time to do the right way. And so the Justice Department designed an expeditious way to deliver Canadians to foreign countries that wanted them. I guess it's part of our history of being good guys in the world. France doesn't extradite to Canada. France would not extradite a French person here on Canadian request. But Canada happily sent Hassan Diab on virtually no evidence, and certainly no sworn evidence. What is required to get an extradition now is called a record of the case. All that a foreign prosecutor has to do is write up a document claiming this is our case. And you can imagine any prosecutor is going to put this at the very highest and not stress the weaknesses in the case if that government is going to the trouble of asking a foreign government, Canada, to engage its process and its resources to detain a Canadian and ship them to this country. They're going to put their best foot forward. Unfortunately, the best foot is not sworn, and it's often misleading. And it was unbelievably misleading in the Diab case. One example alone that I can give you is of intelligence that the investigating judge claimed in a formal document to the Canadian government that they had received that said the terrorists who did this bombing entered France from Spain using their real passports and then switched to fake passports while in France to carry out the act. They then came into possession of Hassan Diab's real passport and found out he had never entered France. This was pre-Schengen, where if you came in from Spain or anywhere in Europe, you crossed a border, there were stamps. Europeans were very meticulous about that. The passport proved he was never there. So what did they do? They sent another letter about 6 months later saying, the intelligence actually told us that they used fake passports to enter France. So suddenly they made, with this unverifiable claim, the passport inculpatory evidence. The fact that it had no stamp in it now became a piece of evidence against Hassan because, according to the intelligence, which they'd changed, manipulated, it proved that Hassan had entered. Think about the Kafkaesque nature of that. So there's the state of extradition law is such that Canadian judges have allowed themselves to go down this path. The Federal Department of Justice comes into these cases with mountains of case books, all of which, one case after another, they built this law. And they overwhelm the judges. And because, in large part, defense lawyers have never done these cases and don't know the law, it's almost like a self-fulfilling prophecy that this has taken shape exactly the way the Department of Justice wants it to. Very little scrutiny of the evidence, an expeditious, greased wheel to get Canadians out of the country. So the law is a problem, but and France unfortunately uses, as the Dreyfus case, two calendar centuries ago showed us, uses secret intelligence as evidence, and still does. But don't, mine is not solely a criticism of the French system of justice. It's Canada failed. Canada failed here. There were repeated failures, in my respectful submission, in our courts here in Canada. The extradition court, the Court of Appeal, and the Supreme Court of Canada. The extradition judge became convinced that he was not allowed to use the evidence of the world experts, all of whom had given evidence before him in written reports and oral evidence, that the French handwriting report was completely unreliable. It wasn't even based on accepted methodology. It was ludicrous. He felt he couldn't consider the evidence, the world's leading experts on handwriting, on the question of whether this amounted, therefore, to unreliable evidence. The test that the Supreme Court of Canada created, because they are worried about the obvious constitutional peril of a system where you don't have sworn evidence, and how can you test it? And can Canadians just be shipped out on basically nothing? So in 2006, they apparently created a safeguard saying the evidence must pass a test that it is not manifestly unreliable. And we demonstrated it was manifestly unreliable, and the judge came to the conclusion, oh, but I can't consider the evidence you've given me on that, because that's the kind of evidence that you would lead at trial. And we said, that's crazy. If we're allowed to show that it's not reliable, we can't call a baker to come in and say in his opinion it's not reliable, or a bus driver. We have to call the leading experts in the world on handwriting. It came down to that for the judge at the extradition hearing. He said, but for the handwriting opinion, which he doubted, he said it was suspect, didn't really believe it, but he thought he had to commit. He did not. And the tragedy is the Court of Appeal said he was wrong in that. But the further tragedy is the Court of Appeal did nothing about it. Court of Appeal let the extradition stand. And then when we appealed to the Supreme Court of Canada, our real hope in this case, because of the judgment in 2006, they wouldn't even grant Hassan a hearing. So we have failed in this country. Hassan's fate is very much on Canadian justice. The French system is difficult because they allow things that for us at trial would be unconstitutional, but that's what Hassan is facing. But we put him in that position. So you have a person who was extradited on one, clearly unreliable evidence, which isn't supposed to happen, two, unconstitutional evidence, secret intelligence, and who was thirdly, and we argued this, it was clear from the French materials they were not asking his extradition to put him on trial. You can't extradite Canadians to a foreign jurisdiction for investigation. It's either you have a case and you put him on trial, or her, whoever you're asking for, or we don't send them. Yet we did that in this case too. And look, he was sent in November of 2014. It's May, edging toward the end of May of 2016. He's been in custody all that time until, last weekend. And he may go back into custody on next Tuesday, and I'll say a word about that in a minute. And there's no trial. There's no trial on the horizon. There's no trial date. This is all about accommodating France so they can conduct an investigation. There's considerable pressure from groups in Paris. They're anxious to find somebody to blame for this. France has a history of anti-Semitism that it is anxious to show that it has overcome. So there are many things conspiring against Hassan Diab in this. But he was never extradited to stand trial because there is no trial. They don't have a case yet, and they're still trying to make one. And he's had to stay in custody all this time while they do it. So now the, I guess, hopeful sign, and he's a remarkable man, how he can smile at all of you through what he's been through. He really has, in his own way, an indomitable spirit and a belief. He actually believes that justice will win out. It won't without all of our help. He was released a week ago Wednesday. That order was immediately appealed and annulled. On Friday, the Court of Appeal canceled and reversed his release order. It came before another judge who reviews detention after 6 months, every 6 months, and he too ordered the release of Hassan Diab. And once again, the prosecutor has appealed. The very same Court of Appeal, 3 judges, one in particular who has always ruled every step of the way against Hassan, ruling that it's fair to use unsourced intelligence, it's fair to keep this ludicrous handwriting in the dossier of the case against him. He will decide Hassan's fate next Tuesday. So I'm cautious lest I become overly optimistic, but there is this. 2 independent judges now have looked at Hassan and the case that they have. And these are the first 2 chinks that we've seen out of France of some form of recognition that, this evidence really isn't very good. You would never release a man in the climate that they are in Paris, if they had a strong case. And you would never release a man if you really believed he was an escape risk or a danger to the public. The Court of Appeal ruled last Friday that he was a flight risk, despite all his time on bail here in Canada, and despite the fact that he's been out now a week and clearly is abiding by the terms of his release, and that his release would cause public disorder. And there has been no public disorder. In fact, I spoke to the French lawyers today, and there are labor issues that are galvanizing France. There are economic issues that the French people are concerned about. But there's nobody taking to the streets because Hassan Diab was granted bail. And nobody will. Despite the best efforts of lobby groups and others to try and whip up some foment about this, there's simply none. That's the hopeful part of this. I guess we're all part of this project. It's certainly interesting. It's like reliving Dreyfus. Maybe we'll find an Emile Zola who will rise up, some prominent Frenchman, to say, stop this. It hasn't happened yet. In fact, my experience has been that the French journalists have very much fallen in line with the anti-terrorist rhetoric of the government. And Zola went to jail for what he did. But all of us in our own way can help. And I think Dreyfus proves ordinary people can make a difference.